I didn't understand half of the things. She had heart failure. You know, it's my grandma, she's 70 years old, something like that. You know, what it happen if you keep me in here and then she just something happens?
Scott,
No, listen.
Mr. Scott, no, you listen. No, you listen.
But
I'm done. I let you out. I gave you a chance. I've given you numerous chances. Saying that anybody's trying to make you look bad, I don't have to go to the past. I let you out. You don't make it 8 days. And now I have you involved in a crime that involves pointing a gun at another person. I'm done.
what do you mean?
Listen,
Can you just let me
motion for
judge?
bond reduction denied. Bond will continue.
Thank you, Judge.
But
Go
you ain't let me speak,
Go
though.
process that.
You ain't even let me speak.
Right from the start, emotions are running high. The defendant is pleading for compassion, but judges have to weigh more than emotion. They're thinking about public safety, prior behavior, and whether a defendant can be trusted to follow court orders. This hearing is about to show just how difficult those decisions can be.
Court calls the case People versus Benjamin Peterson.
Alexander on behalf of people, Your Honor. Student attorney Kara Rose Cameron under the supervision of First Assistant PD Michael Gaddy. On behalf of Mr. Peterson. Mr. Peterson, can you state your name for the court?
Benjamin Donald Peterson.
Thank you.
Your Honor, we're going to be requesting that the court set a date for Mr. Peterson's exam, and we'd also like to address the issue of bond when the court's ready.
You have all discovered.
Yes, to my knowledge.
People have their witnesses available the 8th.
We'll do it, Mr. Honor.
Preliminary examination in person, July 8th, 2025. 9 a.m. before Judge.
Judge Fresh.
Fresh hour.
Thank you, Your Honor. May I address bond?
You may.
Your Honor, our client has informed us that he has no prior convictions and he was extradited from the state of Missouri where he resides. He is willing to stay on a GPS tether and remain in the state of Michigan, or alternatively, he can leave the
So
state.
we had to extradite him?
Yes.
Hey, go ahead.
Or alternatively, he can leave the state of Michigan and not return, and he's willing to do all of his court hearings over Zoom. He does have employment.
Why would we do that if we extradited him?
Here's an important legal point. When someone has to be extradited from another state, it often raises concerns about flight risk. That's why the judge is pushing back so hard against the idea of immediately letting the defendant leave Michigan again. Do you think the judge has a point?
I mean, what? Did he waive extradition? But we had to get him here, right?
Yes, sir.
So if we had to bring him from another state, and I'll wait for your answer, why would I let him leave this state? And why would I let him basically be out of custody at this point?
Well, Your Honor, he's willing to stay in state on a GPS tether.
But he wasn't willing to come here to address these issues.
Yeah, he waived.
Go ahead. I'll let you complete your argument for the record. But
Okay, thank you, Your Honor. I appreciate it. We were just requesting a personal bond, or if the court was not inclined to grant this, a lower bond with a 10% option.
okay, I don't need a response, but thank you for standing. Motion for bond reduction is denied. I think it's rather evident on the record as to why the court is denying that. So his bond is denied. The exam is set for the 8th. Thank you.
Thank you, Your Honor.
Clerk calls the case People versus James Taylor.
Our attorney requesting conviction of practice pursuant to Michigan Court Rule 8.120 under the supervision of APA Andrew Taylor's government.
Duration of practice is granted.
Edward Drucas for James Taylor, Your Honor.
All right.
And I don't see him coming up to the podium. I had been in.
Because he's not.
Missing court is one of the fastest ways to make a legal situation much worse. Even if there's an explanation, failing to appear can lead to an arrest warrant, higher bond, and a much tougher road ahead. Every hearing matters.
He did get released out of Ingham County. I had been in communication with his attorney up there. I did get a new updated contact information, and he may not be aware of this date. I've not been able to speak.
Really?
Mr. Taylor. His last date, he was in Ingham County, and I don't know if, but got released shortly thereafter.
And he has a bond violation pending, which may be a result of him being in custody, but he hasn't come down to do anything. Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $25,000 cash surety. That bond will issue immediately. Yes. Court does call the case of the people versus Barrage Scott.
Please, Judge. Court shall feast on behalf of Mr. Barrage Scott, who is approaching the podium. Mr. Scott, please state your name for the record.
Well, I'm gonna take Scott, so.
How you doing, Barrage?
All right, just glad to see my family in here, that's all.
Thank you, Judge.
Been here every time for you.
Yeah.
All right.
Thank you, Judge. I believe this is a competency review. My understanding is that we do have a report. Scott is competent, Your Honor.
Yes.
We stipulate that, Your Honor.
And the people?
But also stipulate.
All right. The court, having reviewed the report, would find that the defendant is competent to stand trial. Defendant can understand the nature and objects of the proceedings against him and can rationally assist in his defense. Therefore, the defendant is found competent.
Judge, I'll be asking this might be set for a PCC, and Mr. Scott would like me to address bond as possible.
All right. Probable cause conference will be set for July 10th, 2025, 9 a.m.
Thank you, Judge. I've had a chance to talk to Mr. Scott about the situation, and I've relayed to him how serious of a charge he is facing. Mr. Scott is still asking that I seek a personal bond for him on this case, Your Honor. Although the court does see that Mr. Scott is competent, Mr. Scott does indicate that he suffers from a variety of mental health conditions. He indicates that he would love to get this situation resolved. He would love to see this prosecutor's office potentially offer him a mental health court resolution. He says that he's not going to run from this situation. He has family support. He indicates that his mental state is in a much better place now than it was at the time of this alleged event. He indicates that he has a grandmother who is involved in his life and who will help make sure he attends any and all court dates. He indicates he will go to any outpatient or inpatient treatment that the court does require. He also has no objection to being on a tether. He indicates he's willing to just address everything that's going on in his life, Your Honor, that he will not be a problem for Your Honor should the court release him. He's asking that Your Honor consider a reduction in bond or a potential personal bond. But again, I have relayed to him how serious of a charge he's facing. But I believe that's what you want me to argue. Anything else? Mr. Scott says that he's on his medication now, and he's obviously much better when he's on his medication than he is when he's off his medication, and he will stay on his medication should the court allow him an opportunity to be released. And that the nurses in the jail have upped his medication in certain areas and have him on a shot and a pill form.
Yes.
And so his mental mind frame is.
Now we arrive at the hearing's most complicated case. The defense argues that treatment, medication, and family support have changed the defendant's circumstances. But the judge must decide whether those promises outweigh the risks. This is where courtroom discretion becomes incredibly important.
In a better place, and he will do anything and everything the court asks and he's asking for a potential release.
Response.
I would ask that bond remain as currently set. I appreciate Mr. Easter's advocacy on behalf of his client. I'm struck by the language in the competency report. Mr. Scott affected a volitionally uncooperative response out during the evaluation process and attempted to feign legal knowledge, memory deficits, and symptoms of severe. Candidly, if you're uncooperative in the underlying competency evaluation, given his criminal history and the facts of this case, I believe that he is.
This is the moment everyone in the courtroom has been waiting for. The defendant is finally speaking directly to the judge, not through his attorney. Personal statements can be powerful, but they don't erase a defendant's history. Listen carefully to what both sides focus on.
Danger to the community, I guess.
Nothing further, Judge.
All right. I am going to deny the defendant's request for a bond reduction in this case. I think the bond is set appropriately. I would further indicate that Mr. Scott's been appearing before this court for quite some time on various matters. And typically I can let Mr. Scott out of custody. He may come back in, but usually for minor things. Mr. Scott was in custody. I took a chance, released him. He did not make it a week before this came up. Mr. Scott was arrested. So I'm not going to take that chance again, especially since it's
You understand what he's saying
a
to you?
violent case.
Hold on, do you understand what he said to you?
So
He said that he let you out. This happened a
I
week later.
know, but he keeps saying the same thing.
Okay.
Saying the same thing that he's saying.
Okay.
He's not.
I believe Mr. Scott wants to address you directly, Your Honor, if you
go ahead, Mr. Scott.
Listen, Mr. Simpson, I know you kind of keep, going back in the past, right? But this is my life. You know what I'm saying? My grandma's here, my family's here. People are making me look bad. Even a competency hearing, they're making me look bad. I answered everything what I was supposed to answer the right way, and the prosecutor saying I was I wasn't cooperating the correct way, and I was. It seems like I had to take 2 competency tests. And the first one, he just said what he wanted to say. I'm asking if you release me today, because I got to go see Slay today. They said if I do get.
What an emotional ending. The defendant asks for understanding, while the judge points to repeated opportunities that, in the court's view, ended with new allegations of violence. It's a powerful reminder that bond hearings aren't about deciding guilt or innocence, they're about balancing compassion, accountability, and community safety. If you were on the bench, would you have made the same decision? Let us know in the comments.
Release, they're going to follow the same recommendations you will follow if they put me on tether, if they put me in. You never put me in no classes. You never ever put me in no classes or try to do anything like that. I want my days to be filled. If I'm on tether and I have a curfew, I want my days to be filled. I be with my auntie, stuff like that. I go to classes. I go to Don Farms. I need this. I need help. I have a drug problem. I never addressed it like this. But after my sister died last year, she died. She had passed away at 23. I went crazy. I didn't understand half of the things. She had heart failure. It's my grandma. She's 70 years old, something like that. What it happen if you keep me in here and then she just something happens? No, listen.
Mr. Scott, no, you listen. No, you listen.
But
I'm done. I let you out. I gave you a chance. I've given you numerous chances. Saying that anybody's trying to make you look bad, I don't have to go to the past. I let you out. You don't make it 8 days. And now I have you involved in a crime that involves pointing a gun at another person. I'm done.
What do you mean?
Listen,
can you just let me
motion for bond reduction denied, bond will continue.
Thank you, Judge.
But you ain't let me speak, though. You ain't even let me speak.
This hearing perfectly demonstrates why bond decisions are among the most difficult choices a judge has to make. In Benjamin Peterson's case, the court concluded that extraditing him from another state made immediate release inappropriate, so bond was denied. James Taylor's failure to appear resulted in a bench warrant and a substantial cash bond, underscoring how seriously courts treat missed hearings. The most emotional case involved Dante Scott, who spoke openly about his mental health, addiction, and devastating family loss while asking for another opportunity. Yet Judge Simpson focused on something equally important under Michigan law: community safety and the defendant's history of prior releases. After concluding that previous opportunities had not changed the outcome and considering the allegations of a violent offense, the court denied bond and kept the existing conditions in place pending further proceedings. Whether you agree with the judge's decision or believe another chance should have been given, this hearing reminds us that compassion, accountability, and public safety often collide inside the courtroom. What do you think? Did Judge Simpson make the right call, or would you have ruled differently? Let us know in the comments below. If you enjoy real courtroom breakdowns with legal insight and the full context behind every decision, don't forget to like this video, subscribe to the channel, and turn on notifications so you never miss the next courtroom drama.